Now let's have a look together at the torts question from July of 2006. Here is a hypothetical that gives us a chance to look at intentional torts, negligence, and the relationship between various parties in terms of liability. Have a look at the call of the question. This is a very helpful call that can allow us to anticipate quite a few of the issues that are presented. 1. Can Paul maintain tort claims against A. Clerk for false imprisonment and B. Mark for negligence? Discuss. Well, we can obviously outline Part A and Part B of this question fairly completely without even looking at the facts. We know that false imprisonment essentially involves confining the plaintiff to a bounded area. In a nutshell, that's what false imprisonment is. But look a little bit more carefully, and we see that the defendant is named Clerk, which suggests that this is an alleged false imprisonment that occurred within a store. This will allow us to anticipate a shopkeeper's privilege defense even before we look at the facts. And remember, we're always going to think about the defenses as well as the theories of liability. Then, with regard to the second defendant, we don't know anything about Mark, other than that he is being sued for negligence. And we can break that up into duty, breach, causation, damages, and defenses. So without even looking at the fact pattern, we can create, essentially, what will be our final outline before we even read the fact pattern. And this is enormously helpful. Remember, this is a timed exercise, and we're trying to do as much as we can, as quickly as we can. And dissecting the call of the question up front always is worth doing, especially with a problem like this. Now look at question 2, and here's where we get to the liability issues with regard to Delta Gas. So now it looks as if we are being questioned about the company that is responsible for the location that this dispute has arisen in. So we're going to have to analyze Clerk and Mark separately, but it's likely that the first call of the question is going to be the one that requires the bulk of our time. We know that we've got a lot more to say about elements of theories of liability and defenses than we do about potential issues of vicarious liability. So now let's go to the top of the question and review what happened. In paragraph 1, we meet our plaintiff, Paul, and we find out all about his interactions with Clerk. Essentially, Paul is blameless. Paul hasn't done anything wrong here, and as a result of Clerk not really paying attention to what's going on, the result is Clerk accuses Paul of being a thief and then orders him into a back room and then closes the door. We know that the door is not locked, but unless there's something dramatic about to happen, it looks as if the plaintiff has got an entirely valid claim for false imprisonment. And that's regardless of what happens in the next paragraph. It appears as if the tort is completed at the time that the door is shut. The plaintiff is confined to a bounded area, and he doesn't feel free to leave. Probably that's good enough to establish the liability of Clerk for false imprisonment. And thinking ahead a little bit, given that the Delta Gas defendant in question 2 is the employer of Clerk, and seeing as how Clerk was acting within the course and scope of his employment duties at the time that he committed this intentional tort, it's very likely that Delta Gas is going to be vicariously liable for the conduct of Clerk here in this paragraph. Now in paragraph 2, we meet Mark, the other defendant. He's the manager of the store, and he comes back to find the plaintiff in the back room, knocked out from carbon monoxide poisoning. And here we learn about the conduct of Mark in leaving his personal truck and leaving the engine on adjacent to the back room in the garage. He leaves the place to go on his errand, he forgets to shut off the engine, and the result is the harm to the plaintiff. We also find out about the defense that is likely to be offered at the end of paragraph 2, where Mark says that he is taking medicine and that caused him to forget. Well, that's not going to be a defense to negligence. It may be a defense, but it's not going to be a successful defense. But certainly we do want to talk about it. We definitely need to find a home for these facts and to connect these facts to elements of the theories of liability or to defenses. Next, in paragraph 3, we learn about the continuing damages suffered by the plaintiff. He continues to have headaches, and we also find out that he heard the engine before he passed out. And this is a detail that requires a little bit of creativity to incorporate into an answer. I'll suggest one way to do that in a moment. Then, in the last paragraph, we get a statute about how one is supposed to handle vehicles that one is going to park. And the obvious reason for this statute is to require us to discuss negligence per se with regard to the defendant Mark in Part B of Question 1. Now, we've already outlined this part of the question before we even read the fact pattern. And now that we find out about this statute, we can flesh out our outline to consider negligence per se. And, by the way, that is a fairly good way for a plaintiff to establish a breach of duty without showing anything other than the violation of the statute. So, then, we're back to the call of the question again. Now I encourage you to turn the page and have a look at the outline of issues that I've presented. And you're going to see that I don't really do much more than I was able to do at the time that I first read the call of the question and the fact pattern. As you look at calls of the question 1 and 2 for the lawsuits between Paul and Clerk and Paul and Mark, you'll see essentially all I do is break the issues down into elements and then have a final headed section called a conclusion. With regard to Paul versus Delta Gas, this is not a very complicated section, at least compared to the previous sections, and so we're going to talk about vicarious liability up front just to explain what it is, and then we're going to focus on each of the defendants. In the end, we're going to conclude that Delta Gas is likely to face a fair amount of vicarious liability for the actions of its employees. So, in a nutshell, that's the way to organize an outline and spot all of the issues that are presented here. But on every bar exam in the country, not to mention just about every law school examination, your job is to do more than merely spot the issues. What you need to be able to do is analyze the facts in the question, distinguish between the important and the less important facts, and to expose all of your thinking to the page that you are writing on or the laptop that you are typing into. You want to express explicitly how you interpret as many of the facts as possible. Now turn to the model answer that I present, and this offers yet another example of exactly how to do this. Now, remember, there's no one right way to craft an answer to any essay question. Almost always, answers that receive equally high scores are different from one another. But what they have in common is they spot the issues and they analyze the facts. And you will see that, as usually is the case, I lead with the facts up front. The very first paragraph of my answer contains 2 comparatively short sentences, and it sets the stage for what will follow. I introduce the plaintiff, and I define false imprisonment about as briefly as you can. Remember, we are getting points for analyzing the facts, not merely reciting the law. So, with regard to intentional confinement, you'll see that what I essentially do is I report on the facts and then I interpret them legally. Ultimately, I think it's pretty obvious that Clerk intentionally confined Paul to a bounded area and that Paul didn't feel free to leave. That looks pretty good as far as establishing the plaintiff's claim. Next, I focus on the bounded area, and here again I find a home for as many of the details as I can shoehorn into this part of the answer. I want to show the reader that I know the law and that I appreciate the consequences of all the different facts. So, in the end, it is very easy for this plaintiff to prove that he was confined to a bounded area, even though the door wasn't locked. Next, I focus on the shopkeeper's privilege. I explain what the shopkeeper's privilege is, but then I focus most of my attention on what happened in the fact pattern, and I interpret it. It seems that if the clerk had been paying any real attention to what he's supposed to be doing at the time, it would have been obvious that Paul had paid properly for the candy, just as he had previously, obviously, paid properly for the gasoline that he bought, and he would have been able to avoid all of these problems. So I conclude that the plaintiff's claim for false imprisonment against the first defendant is valid, and notice how I focus on what the plaintiff is going to get. I contend that he's going to be entitled to compensatory and punitive damages. And I don't go into a lot of depth about that because there aren't a lot of facts in the pattern that require analysis. The facts in the pattern are going to the liability issues, and so that's where I concentrate the bulk of my energies. Next, let's turn our attention to the negligence action between this plaintiff and the second defendant, Mark. Again, I lead with the facts. I don't spend a lot of time merely reciting the facts, but I do set the stage for what's going on. I indicate that Mark was the manager on the day of the injury, and I focus again on the elements. Then I go into duty and breach. Under breach, I find a home for the negligence per se analysis, and notice that I don't quote extensively from the statute involved. I think that this would be essentially a waste of time. But I do make it clear that I understand what the statute was about and what it said. It seems quite apparent that there is per se negligence. I grant that it's a somewhat close call, and most bar examinations testing issues like these aren't really looking for a quote-unquote correct answer. But speaking as a defense lawyer, I think this plaintiff has a pretty good claim, and I think our plaintiff is going to prevail if it comes down to a contest in court. Notice on causation that I focus on the but-for and potentially intervening causes that might break the chain of causation. This is a deceptively complicated fact pattern. As we get into it, we see that although the defense doesn't really have any successful defenses, there are facts in the pattern that each defendant is going to focus on in an unsuccessful effort to avoid liability. So our job is to very meticulously identify and focus on exactly what happened. So here, at each step of the analysis, factually, you're going to see in my answer that I explicitly mention how each fact that happens after the initial act of negligence is a potentially superseding force. Now, in my analysis, and I think in the analysis of most people who write good answers to this question, we see that the chain of causation really is not broken. One other detail about this question that I wanted to mention before I turn to the next section is the potential for liability being different depending on the status of this plaintiff, of this defendant, Mark. Thinking about real property law and liability, I think it's obvious this guy is the plaintiff is a business invitee, and so the duties that are required are pretty clear. The plaintiff is not a trespasser, and he's not a family guest. And I don't dwell on those distinctions very much, although I do allude to them. It would be possible to spend more time than I've chosen to spend on making those distinctions so that you could show a reader that your understanding of the liability of people who are potential victims on another's property can be distinguished. Here, I don't give that a great deal of attention, but one certainly could have done so. Now, next, in focusing on the negligence action, I focus on defenses briefly, and you'll see that I find a home for the details, both about the defendant's medication and also for those facts about the plaintiff hearing a car engine before he passed out. And I focus on those facts as a potential defense to negligence because the defendant might contend that the plaintiff could have had the last clear chance to avoid his harm and might have escaped any damages by just opening the door. But I think under the facts, it's not going to be reasonable to assume someone or to expect someone who is passing out from carbon monoxide poisoning to make that kind of a decision. Next, I turn to the vicarious liability issues with regard to the third defendant, and you'll see that I do spend a little bit of time up front focusing on exactly what vicarious liability is and how it relates to the parties that are present in this fact pattern. Then I focus on the facts and on the status of Paul as a business invitee. And it seems evident to me that Delta Gas is going to be liable for the harms that were caused by each of their employees. And that's enough to consider all of the general issues that are presented in this fact pattern. Again, reasonable people can differ as to how these facts are interpreted. But I think you'll have to agree, I find a home for all of the details, and I clearly identify the issues and reach specific conclusions as to each one of them.